On the 27th of August 2010, Kenya ushered in a new constitution.
And it is presented to His Excellency.
As Kenya's third president, Mwai Kibaki displayed the new document after appending his signature, it marked a new dawn for Kenya, which
A very good evening to you and welcome to a special edition of Checkpoint. My name is Sophia Wanuna. Apologies for that technical hitch with that report. A report by George Maringa that was seeking to set the stage for why the debate we're having this evening is important. So tonight we're coming to you live from Daystar University for the Law Society of Kenya debate for the position of male representative to the Judicial Service Commission. Now, JSC is a critical, independent institution that is meant to ensure the judiciary, which is an arm of government, plays its role. Now, this conversation tonight matters to you. Why? Because one of the other roles of the JSC is hiring of judges all the way from the Supreme Court and the other courts, disciplinary action of judicial officers, as well as removal from office. So whether directly or indirectly, the important decisions by the Judicial Service Commission matter to you. So members of the audience here tonight with us at the Daystar University have been asked to remain quiet throughout this debate. No cheers, no jeers, no applauding, no clapping, except for this moment as we welcome the male representative to the JSC from the LSK candidates. Now, this is according to the order of a ballot they took a few moments ago. So, ladies and gentlemen, help me in welcoming Irungu Gadi. Also with us tonight is Macharia Njeru. On the third podium tonight is Professor Tom Ojenda. And last but definitely not least, Charles Ongoto. So, gentlemen, we welcome you to the 2019 Law Society of Kenya debate, as I mentioned, for the position of male representative to the Judicial Service Commission. The debate will be divided into three thematic areas. One of them, fitness to serve in the JSC, the independence of the judiciary, and accountability. These thematic areas and topics had previously been shared with all four of you. Now, the debate, as I mentioned, will be going on for the extent of this hour. We have up until 11 p.m. And of course, the questions in this debate have not been shared with anyone. They are my own. I will now take you through the rules of engagement during this debate, those as well shared with you earlier. Each candidate will have 90 seconds for your opening and closing remarks. You will have 2 minutes to answer the questions that I will put to you. There will be an allowance of 1 minute for rebuttals in case any of the other candidates mentions you. There will also be 1 minute for follow-up questions in case anything you say is not clear. When your time is up, you will hear this sound. And at that point, you are expected to stop speaking. We will also be taking questions from members of the audience with us here tonight. And my colleague George Maringa is at hand, and George is waving, at hand to receive the questions that will be written down by those who may wish to ask questions, and also include your name as you write your question. And my colleague George will read out those questions when we get to question time. That said, let's get straight to our conversation this evening. So those opening remarks, Irungu, you are fast to go. 90 seconds. Start now. Talk to us about who is Irungu Gadi. Why is he seeking to represent the LSK in the JSC?
Thank you very much. My name is Gadi Irungu. Firstly, I have a very vast experience of 28 years in practice, all courts, from Supreme Court to normal tribunals. And then I'm also a mediator and arbitrator. And my aim is that with that first experience in practice, I know the shortcomings and the issues that we, as members of Law Society of Kenya and main stakeholders, do have the issues that concern the judiciary. And we want to go there and represent the Law Society of Kenya and the lawyers especially, because they are main stakeholders. And my first experience in practice, and also even in learning institutions like the Kiambu County Assembly, will stand me in good stead. And basically, what has happened, and finally, is that elections, and this is to my colleagues, elections come and go, but our Law Society of Kenya is going to remain. So we want to do a civil campaign so that we can move forward. And like I've said, as a mediator, arbitrator, I'm able to
All right, your time is up, sir. Thank you.
Thank you.
Mr. Njeru.
Thank you, Sophie. My name is Macharia Njeru, as has been indicated. I've practiced for 28 years now. I've also served in both public and private corporate institutions. I served as chair of a bank in Rwanda. I served in a board of a bank in Uganda and also in Kenya. Served as the inaugural chair of the Independent Policing Oversight Authority. I served as the chair of the board finance committee of Anglican Church of Kenya, Nairobi Diocese. I've served as chair of many private charitable institutions. I have a lot of experience, both in private practice and these institutions, in setting up corporate governance structures. And what we need in these critical institutions, being JSC and judiciary, right now, is somebody who has that experience so that we can ensure that systems and processes are put in place. We institutionalize them so that we can have efficiency, we can have accountability, we can have ethical practices, and the country would benefit out of that. That's what I'm able to bring on board. And I believe that's the reason why I've offered my candidature, so that we can take these institutions forward.
All right, Professor Ogenda.
Thank you, Sophie. My name is Professor Tom Ogenda, Senior Counsel. I am running for a second term as a Commissioner of the Judicial Service Commission. I have previously served as President or Chairman of the Law Society of Kenya, President East Africa Law Society, Vice President Pan-African Lawyers Union, Council Member International Bar Association. I have published over 10 books, written over 25 articles in refereed journals, Professor, Moi University School of Law. But let me say this, that professionally, I have been within the Law Society leadership for many years. During this time, I have mentored young advocates. I appreciate the role of a commissioner at the JSC. These are commission of 11 commissioners, and the main role of the commission under Article 172 is oversight and fostering accountability, hiring judges, judicial officers, and setting pace for discipline of judges. The JSC has performed.
All right, and you'll get to talk more about what you, especially having being an incumbent, has done. Mr. Ongoto.
Oh, thank you. As you have heard, my name is Charles Mungaro Ngoto. I've been in active practice for the last 19 years. When I say active practice, meaning practicing on a daily basis in these courts. Why I decided to contest for this position is because I do understand the problems that we face in these courts. Lawyers and the public face a lot of problems while litigating in their matters. And I decided that instead of sitting back and waiting for somebody to come and fix those problems, I realized I have the ability, the capability of doing those, fixing those problems. You've heard, I've not served in any commission, but I have the experience of 19 years in court. And what you lawyers and the public need is somebody who has an experience in court, a very clean record. And I've never had any issue in court. And that's why I said, I'm the best person. And in fact, all of you could see, even as we are here, you could see I'm different, dressed differently. indicating the seriousness on which I take this position. And that's why all of them came casually, knowing that Ongoto is there, he will take charge, he will serve the judiciary. And in fact, the matters, the problems we face in litigating, certificate is budget. Oh, thank you.
All right, thank you very much. Iringo Gadi, of the 4 candidates, we did not receive a manifesto from you, despite asking on 3 occasions. But let's get to the point that you submitted your application a day after the deadline lapsed. Isn't that correct?
Very correct.
And then you were locked out, but in a decision of the LSK, you were subsequently allowed to vie. So point 1, isn't that a mockery of the requirements to vie, that you would file your papers a day late, but also for those who question the seriousness of your candidacy? What do you tell them?
Thank you very much. Firstly, we are the Law Society, and I'm sorry, seem to have a candidate, their candidate up there. But let me tell you, one, when we are talking about nomination, we are also talking about taking those documents. Firstly, the documents, the Law Society closed the offices, which are out of town, at 5 instead of midnight. That's firstly. And that is why we brought the document the following day. Secondly, that is not a requirement under the Constitution, under the Judicial Service Act and the Law Society Act. So basically,
what is not a requirement, sir?
About the way you bring at what time you bring the documents. We are firstly qualified, and thirdly, these documents were put there for months doing nothing. No action was being taken on those documents. So no prejudice absolutely has been occasioned to anyone. And finally, we believe that the Law Society members are the voters. They need not be disfranchised, and they need to go and vote their candidates that they feel is capable.
So was your plan to submit your forms at midnight?
They closed. I've said they closed the offices at 5.
Yeah.
And even in national elections, in fact, they have 2 days when you can present your documents, and then of importance, and that's where we need to move these documents. And when we are talking about Law Society of Kenya, the offices are in Nairobi, and they should allow online applications. People are no longer in these walking and walkout issues.
So a quick follow-up on that point, sir. So what is it why did you have to wait until the last minute that got you locked up? Because submission and the deadline was not a one-day affair. You had time, which you did not keep. So then why then go day after and then say you were locked out because they should have closed at midnight? That does not add up.
For your information, nobody locked us out. We took our documents, and the council, in their decision, decided that we are candidates, and that is where we are. Thank you.
All right, thank you. Mashara and Jerry, you served as chair of the Independent Policing Oversight Authority. And in your manifesto, you list some of the achievements there. You talk about 67 officers were charged over extrajudicial killings. You say that you're able to reverse a corruption-tainted recruitment exercise. So the question I put to you tonight is, there are those who'd say with 67 charges, what about the convictions? Because as you seek to join the JSC, one of the big concerns in the delivery of justice in Kenya is we see a lot of people charged in court, but in as far as convictions, that it continues to be a big issue of concern. And to say that you stopped and were able to reverse the recruitment exercise that was tainted in corruption, that's a product. What about the root causes of corruption that we've seen year on year, the police being ranked as the most corrupt in the country?
Thank you, Sophie. Now, let us start by understanding that Independent Policing Oversight Authority never existed. I was the chairman who was appointed after going through a very thorough vetting process and also recruitment process that involved the members of parliament. And I was tasked to set up this institution from scratch, which we managed to do within 6 years. Now, setting up an institution is no mean achievement. It's a very difficult exercise. Remember, in the whole of Africa, the only equivalent we had was South Africa. And it's only in other jurisdictions like UK, US, New Zealand, etc. that have similar institutions. We're able to do it. And I can tell you that apart from setting up the corporate headquarters and the other 10 regional offices, we recruited staff, we trained them. We had never had staff from where we could pick because there had never been oversight institution of a similar nature. We set up 44 policies. Then we came up with the HR manual and also the investigations manual. Set up systems, processes, made sure that the institution was fully digitized. Then we started also on investigations. We concluded 764 investigations, forwarded 108 files to the ODPP, had 67 police officers charged. By the time I left, yes, 3 had been convicted, but more have been convicted soon thereafter, even after I left. Let's not forget that there had never been a conviction of a police officer on human rights abuses in this country. It happened for the first time after IPOA came into existence. There had never been any police officer who had ever been sentenced to death because of human rights abuses. That happened because of IPOA. In fact, as we speak now, 3 police officers have been sentenced to death. The last one being the OCS, the Ruaraka OCS, who had been, who was charged because of killing, an innocent guy in a police cells. These are no mean achievements because you're talking about not only setting up the institution, but also making sure it functions.
All right. Professor Ojenda, you're the incumbent on this panel tonight. 5 years already served in the JSC. And the question to you, why continue to serve? I'd read your manifesto and a lot of the achievements you list, from additional courts around the country, more judicial officers being employed, reduction of the backlog of cases, could be argued as corporate successes. So what can somebody say, Professor Ojenda, the individual did in the JSC and needs another 5 years to continue?
Sophia, let me confirm to you that JSC operates as a constitutional entity under Article 171 and exercises functions under Article 172. You cannot, as a single commissioner, present your individual achievements except for the contribution that you make on the floor of the JSC and the particular minutes and agenda that you bring that then are a demonstration of success. For instance, when I came to JSC, advocates were never hired directly to the position of chief magistrate or senior resident magistrate. They would only start either as RM or as judges of the High Court, Court of Appeal, or Supreme Court. That was a main achievement for the LSK representatives. Now, the pull and push in JSC requires a lot of independence on the part of LSK representatives. And that is a role I have constantly played. We played a specific role when we hired the current members of the Supreme Court and the Chief Justice. The reason why I want to continue is to be able to be part of the implementation of the blueprint of Chief Justice Maraga sustaining judicial transformation, which took over, or which was basically a continuation of Chief Justice Mutunga's judicial transformation framework. It's a 7-pillar agenda, very ambitious, but which will achieve or build on access to justice, which will build on and ensure that we have a strong judiciary that will act as a relevant check to other arms of government. Let me tell you this.
I will ask a quick follow-up question as you make the point you were about to make. Your counterpart on the panel tonight, Macharia Njeru, has made a commitment to, if he gets elected, serve for only 1 term. Don't you think you need to give time to other lawyers to also serve? But as you say that, and you answer that question, what is this you will do for this extra term specifically if you are elected?
Sophie, you have just heard this tonight, that Macharia Njeru served for 6 years and was able to get 3 convictions. Those convictions were by the judiciary and by the JSC. So you can already see those gains. Now, President Uhuru Kenyatta was elected for a 2nd term because of the stellar performance in the 1st term. I'm seeking a 2nd term because we have performed. I'll tell you this just briefly. From 15 caddies now we have 56. 155 judges from 55. 592 magistrates from 352. Over 100 court projects going on with 12 new brand new courts.
All right.
This is great, man.
Let me come to you, Mr. Ongotto. You indicated you've practiced for 19 years now. What would you say is your significant accomplishment or contribution to Kenya's jurisprudence?
That's a very good question. I've done a lot of contribution to the judiciary. One, what one needs in this judiciary is honest practice. If we had to fix this judiciary, we must, all of us, do honest practice. I've done so many cases which are reported, some which are not reported. And also, I've been involved in several meetings, in several discussions on how to improve the judiciary.
Are there any landmark cases you can tell us about?
Yeah, there's one landmark case. I don't remember the case number, but there's one I sued the government on appointments on some representative in the constitutional making, and that case is reported. It's only that I didn't have the authority here. And also, what we need in this judiciary, and I can tell you for sure, we need honest people, honest practitioners, people who are ready to serve lawyers and the public at large in a very, very honest way. What I intend to do is to ensure that we have an effective, efficient, transparent, and accountable judiciary. And if I'm elected, I assure you, and I promise all of you, that there's things you see happening in courts, some simple things, like judicial officers coming to court late, lawyers waiting there for hours, rulings, a simple ruling, taking HS, judgments.
How will you do that, sir, specifically?
Yes, specifically, I'll introduce a system together with other judicial office commissioners to follow up on the performance of judicial officers. I can tell you one thing. Like going to court, judicial officers coming to court late is a very simple thing. You've seen people going to court waiting for 3 hours. A judicial officer walks in, doesn't even apologize, doesn't say anything, and people have been waiting. Thank you.
Because I interjected, I will give you 30 more seconds, please.
Yes. You see, that's the problem that we have. Judgments. You see, people say, oh, we don't have enough funding. Some judgments which have been taken years, those judicial officers would reach judgment. Action would be taken against them.
Okay.
And that's the only way we will succeed is by taking swift and a quick action against lazy judicial officers.
All right.
And that I'll ensure it is done.
Mr. Irungu, let's come back to you. And there are some court matters. We're expecting decisions on Tuesday, May the 7th, that touch on your clearance. And if, of course, we're not going to get into the matters, the merits or merits of the issues in court, but if the rulings on your clearance go against your favor, do you intend to appeal?
I have no doubt that the court will rule for us because basically we have fulfilled the conditions in the Constitution and the other statutory laws. But in any case, because for the sake of Law Society of Kenya and my colleagues, if the case goes against me, I won't appeal. Because,
you will not?
I won't appeal,
okay.
Basically. What I'll be able to move on. Because, like we are saying, elections come and go, and we are there practicing and doing other things for this country, for Law Society of Kenya. So why would we mind it's life and death?
Yeah. Do you think the LSK's conduct has been tainted by the kind of developments we've seen in the recent past in the lead up to this election, whether it's the clearance questions, the matters that are now before court, a decision is made, then a reversal, the LSK Council, has that tainted, and even the amendments to electoral laws in the LSK?
Sophia, my belief is that the Law Society is not on the right route. Many years ago, I can remember the Law Society that we supported, that fought against dictatorship, that was in forefront in administration of justice. But what is happening here about the fights and all that, it shows it has a bad showing to the public at large. And these hurabai about the elections, it has caused a lot of, because we are working, we are part and parcel of the society. Are we going back to the, even the way we are campaigning, are we going back like our country, how it is? Because the society should look upon the lawyers as people who should show the way.
All right.
Yes.
Njeru Macharia, the question of these matters that are before court and are largely touching on what many Kenyans have witnessed in the recent past, whether it's the clearances that have been contested, when those decisions are arrived at, because it will be a day before the election. What are the options you see having as a candidate?
Let me first start by saying that I complied with all the conditions. I read them. There was the Electoral Code of Conduct. I complied. And I presented myself knowing very well what were the conditions that were attached to it. So I did comply. But having said that, we are in an election. We are four of us. My personal preference as a candidate now is that we have an election with all the candidates. I am ready for it on 9th, Thursday. I would prefer, as Macharia and Njeru, I have four of them so that I can have a decisive win without anybody thereafter complaining and saying they were removed. That is the preference of Macharia and Njeru. As to what the court will say, I have no control. Whatever is decided, I live by that decision. But I want an election on 9th, this Thursday of May. I get a decisive victory, and then we get into the business of ensuring we have a JSC that functions, that is able to not only serve the lawyers, but also the country, because that's what we need at this particular moment.
Right. Professor Ojenda, the move by the LSK to amend its regulations and what has been arguably lower the standards for qualification to vie for a position. There's debate about, can this apply retroactively? Why would somebody do this to be seen to favor their candidacy? You used the same regulations when you vied the first time around. The female representative to the LSK went into the JSC using this requirement, so that when it changes, isn't this to be seen by a person who should be defending the rule of law as subversion of sorts?
Sophia, there is no subversion. The members of the Law Society are the supreme body when they convene at an annual general meeting. And they can change the rules that govern them. It's a society. And when council decided to send out nominations for elections for JSC 6 months before those elections, and I'll leave this for you to consider. The same day that the nominations were released is the same day my tax compliance expired, the same day. It is the same day that we were given 10 days to send nominations. And in fact, on the same day, one official from Law Society asked me whether my tax compliance was valid, because they had decided in their code to include a requirement that candidates bring tax compliance, yet they forgot to read Article 171, for which states that a serving member only needs to indicate their desire to seek a second term. Because they are serving and they are eligible, they are in the commission. I was required to go through the other processes, that's fine, but there was too much that met the eye at the time. We then went to court, got orders. After we got orders, Sophia, LSK sat on the approvals. After accepting the nominations, they still sat for another 2 months. As Irungu has said, this was not a nomination in good faith. It was all along intended to favor certain candidates. It was skewed. And I agree with Irungu that this process has tainted the image of the Law Society irreparably.
Yeah.
Moving on to the question of the process.
And And your time is up. We will come back to you. Let me bring the question then to Mr. Rongoto. And do you share the concerns around how the Law Society of Kenya has conducted itself in as far as the clearance of candidates to the Judicial Service Commission?
Thank you. First, I should say this. All candidates are supposed to fulfill the conditions as given by the Law Society. It was a mistake for the Law Society, after appointing a vetting committee, to go back and change those rules. Personally, I have no problem with any candidate. And I have no problem with any candidate winning these elections. But the rules must be followed and they must apply to everybody. Let's take, for example, if they change the rules, anybody, even today as we sit here, can forward these nomination papers. Let me ask you, you are going to represent Judicial Service Commission, where you are supposed to ensure that justice is delivered to everybody. Members around to appear there, some don't have their papers, some were raided. Are you going to change so that you accommodate a candidate who has come late? It's not possible. And the law said, let me be open. This one, you messed everything. And it's a shame that we are lawyers who know the law, who are supposed to follow the law, then we do things which are same as in the public. I say, and I'm not fearing to say this, that you let us down. However, now that we are all of us contesting, let us contest. Lawyers are very intelligent people, very wise people. They make their choice. In any case, this is an election where the majority decides. And if they decide whichever way they decide, that's it. But I'm telling you, you lawyers, it's only Ongoto is a serious candidate here. Just elect me and vote for me, and you all of you be in safe hands. There's no gambling here. If you are going to gamble, we'll face serious problems in future. So I urge you, and I humbly request of you, vote for Ongoto. That's it. And you will be safe, in very safe hands.
This will serve as a follow-up so that we wind up on the subject of these developments around the clearance to vie. Professor Ojenda, will you appeal if the rulings on Tuesday go against you and find you that the clearance for you to vie was unlawful? Can
I just speak up and complete?
You only have a minute. Yes.
The other question was, there was no LSK code on elections, and therefore it was within the power of members on the 30th of March 2019 to pass and to decree a motion removing the unconstitutional requirements upon a motion brought by a member. So that is the proper thing. So to the extent that LSK as council adapted, council decision was subject to the decision of the AGM. And remember, the AGM dealt with a live question. There's no question of retroactivity. But regulations, again, can be retroactive.
Will you appeal?
But when the court decides, Sophia, I'll tell you this. The judge hearing the matter is an independent judge. The judiciary is an independent institution. I will respect the decision of the court. As to whether or not I will appeal, it's something I cannot say because I do not know the outcome of that decision. I cannot appeal against a decision that could be in our favor. But I agree with Macharia on the fairness question, that you allow everyone to run in an elected position. Allow everyone to run.
I'll give you 1 minute, sir.
We shouldn't allow this to pass. There was an electoral code of conduct of elections, which we had all signed, including him. The issue of tax compliance certificate, he had even challenged that matter in the High Court. And that matter went to the Court of Appeal. It was a subject that was discussed there. He couldn't have gone to the High Court seeking exemption from the High Court if he didn't know that it applies. Then again, it makes a mockery because, Sophia, the judicial officers who are being recruited are expected to have tax compliance certificate. What sense does it make for somebody who is recruiting the officers, does not have a tax compliance certificate, and the ones you seek to recruit are required to have it? But having said that, I want to repeat, I want Tom Ojenda on the ballot paper. Let us have the election on 9th of May. I pray every night that he be there together with the rest. Let the lawyers decide.
Irungu, I bring this to you. There has been debate around whether lawyers serving in the JSC should continue practicing. Do you support? If yes, why?
It's a very interesting question, considering that you are the employer and also now you are also you appear in court before the people you have employed, the people you may need to promote or discipline. My opinion has been that it's not fair to practice if you are JSC member. And the question is out there, even in universities, about that position. But then, if the judiciary is fake, is corrupt, you don't need to appear before them to corrupt them. So the issue is deeper than just appearing. So we need to make the judiciary independent, corrupt-free. So the issue should not be of utmost importance.
Okay. Macharia, you have made a commitment that you, if elected to the JSC, would not appear in court. But the question that then would be asked, because you argue that would be a conflict of interest, but you have a law firm, and it would then be possible, perhaps whilst yourself not appearing in court, to influence matters being handled by your law firm. What do you tell people with that concern? How do you create a clear boundary that is visible for all to be able to judge that you're truly not interfering?
Sophia, first and foremost, I'm a firm believer in values and integrity, which I've practiced and have a track record regarding that. Secondly, what is critical is that we must make sure that everybody who is a JSC member does not make physical appearances in court. Because look at a scenario whereby you have a judicial officer who is intending to be promoted, who has applied for a promotion, and then that person knows that you can influence whether they'll be promoted or not. Or somebody who have a disciplinary issue before them. Or somebody, for whatever reason, who knows that they require other favors in whatever form. It doesn't make any sense at all that you, the person who is the lawyer, who is also a member of JSC, you are appearing before the same judicial officer. In fact, I can say, Sophia, that in itself undermines judicial independence. And this is something we should not even be arguing about. Now, when it comes to a law firm, it's a different thing. We've had Court of Appeal judges who had law firms that still retain their names. It's not a big deal, it's the physical appearance.
All right, proceed to the question, Ojenda. I'd given you a minute, sir, but Professor Ojenda, as you speak to this, because you are seeking to have another time you practice as senior counsel, do you not see that conflict, that there would be intimidation?
Sophia, Articles 248 and 250 of the Constitution, read together with Article 171, create the JSC as a part-time commission. It is not a full-time commission. In that JSC, we have judges who sit to hear cases and from whose decisions other judges sit. Mm-hmm. We have the Attorney General, who is the biggest litigator in court. We have other members. To say that the Law Society member or the lawyer should not practice their trade would be to say that the judges who sit in JSC should not therefore go to court. Chief Justice should also stop sitting in the Supreme Court. That is a selective view, because the question of conflict of a JSC member is perfectly dealt with by the law. Number one, JSC sits in a quorum of 6. There's no way the LSK male representative would be an angel and more powerful intellectually than the other members.
All right. Ongoto, your views on this debate. Should there be a clear line? And as you answer that, please speak as well to even the judges. There are 5 of them in the JSC. Whilst they're not appearing before their colleagues, but there's a concern of when disciplinary action needs to be taken against them. Is also that intimidation arguable factor? Does it apply as well?
Thank you. That's a very interesting question, but which is also very deceptive. For a JSC representative to influence, you don't need to appear personally. For me, I'm not buying that idea that you don't practice. In fact, this position is for practicing lawyers. If it were not so, then you can bring even a farmer to come and represent us. Corruption is not about appearing in person. If you are a law firm, you know, my law firm is here, Munguta and Company. And every judge, every magistrate knows that is Ongodo the member for JSC. If I want to influence, it's a question of in the evening calling the judge and telling him or her, please, can you do me a favor? So it's about honesty. If you want to say that you are not appearing in court, wind up your firm. Then we can believe you. This deceptive campaign must stop. And the lawyers must see beyond deception. Corruption, you don't carry money in bags to court. You meet in drinking places, social places. You can even go to Tanzania to give a bribe. It's not in court. So, my friends, let us not make a big issue out of nothing. We must appear in court so that you know what problems lawyers are facing. How do you serve lawyers and the public if you are not practicing to experience the daily problems? In fact, bribes are carried outside the courts. And the GSC person, you only need to be honest as Ongoto. And then you serve the members. Members, let us not debate on this. This is a position for lawyers, practicing lawyers. And in fact, what is the law? Is there any law that bars anybody from practicing? There isn't. Until such a time.
What do you say to the proposal? A quick 1-minute follow-up. Yes. What do you say to the proposal by a member of parliament to change the law to bar lawyers from practicing while serving?
Yes, that is okay. If they can make it a permanent job, then it's all right. But not a move intended to achieve or to assist any candidate. You see, JSC did not start yesterday. Now we are seeing a motion by some member from somewhere that anybody who is elected as JSC should not practice. Okay. This is not a permanent job. Let us change the law, then we all accept that. And let me tell you, just 1 minute.
Yes.
Anybody looking for a JSC position and is not ready to obey the law and respect the law as it is now, then he cannot obey it, he cannot respect it as a JSC member.
All right, thank you very much. Macharia Njero, I'll give you a minute. Everybody will have a minute on so that we close the subject of representation. Yes.
Thank you, Sophia. There's the law, there's the morality behind it. Perception of any conflict of interest, even if it's not there, real or perceived, should be bad enough. Because you can imagine, Sophia, if you have a client on the opposite side and who is represented by an ordinary lawyer, then they are seeing a JSC member who is on the other side. They do not feel that they'll get justice. But more importantly, look at it this way. One, I do not support that proposed bill to bar people from practicing, because there's a difference between practicing and appearing in court. We are not saying somebody should not practice. You can practice but don't appear in courts. But let me give you a direct example of one of the conflicts that would arise. My colleague here was one of the lawyers in the Wajir case, which has been very controversial, where there has been allegations of exchange of money. I don't know whether it's true, whether it's not true. I can't determine that. But can you imagine, this is one of the matters where there was a petition that was presented to JSC against particular judges of the Supreme Court. He was a lawyer in that matter. Now, would he sit in that matter? Obviously not. If he doesn't sit in that matter, what has he done? He has denied opportunity to lawyers to have able representation by somebody that they elected. That in itself should be a clear example of potential conflict.
Because you have mentioned him, I will give you a rebuttal for gender, but I do need a quick clarification in 10 seconds, Mr. Njeru. You talked about perception of interference. So would you, as has been mentioned there, be willing to say for your firm, stop practicing, as you say, you will not appear for the duration if you are elected are in the JSC?
You see, the firm, what I said is that the firm is different. The firm is not contesting here. It is me as Macharia Njeru who is contesting, which is why I'm saying that do not appear. For me, I've not been forced by anybody. I know what the law says. I've sworn an affidavit because I've listened to lawyers. I've talked to them.
It would be argued it's your firm. You have access to the matters that are coming before it.
You see, the issue of access could apply to anybody. Okay. You don't have to be in JSC, anybody. Yes. That's what I'm saying. Let's distinguish that by saying, do not make physical appearance. And I've spoken with so many lawyers who have the same opinion.
Thank you. I will come to you, Irungu, for a rebuttal quickly, because he has mentioned a matter you specifically were involved in and the perceived conflict.
I just wanted to tell Mr. Macharia Njeru that is where you go wrong, because you have not been practicing in court. So you can't swear an affidavit. But let's move to the other question. For Kanini Kega, that member of parliament is doing bidding for Macharia. Because it is only Macharia who has said he will not practice. So this is a bill intended for one person. And he's also wrong. But let me move to another question. What of the independence question? Make JSC a full-time commission. In the Wajir case, as I respond, I agree with Macharia that I appeared with Mr. Ngatia for the governor, and that we won that case. One of the few cases I won in the Supreme Court. I lost many others, including Wambora's case. But there's no advantage that a JSC member has because courts are independent and are competent and make decisions on the basis of law and fact before them. Part 5 and 3 of the JS Act deals with questions of conflict. And like in the Wajir matter, I cannot sit because of the appearance. I don't appear in all matters where there are complaints. But as I've said, there is no danger. There is nothing, no conflict that has no resolution because investigations are done by the ombudsperson, not by the members. And when matters are presented before the commission, as I said, there's a quorum of 6, but above all, there is a provision for recusal.
Okay. Irungu, you had a...
Yes, Judicial Service Commission has moved from those days when it was the president who appointed them. And we are moving, evolving every now and then. In places like UK, we have an independent Judicial Service Commission that deals with discipline and appointments. Maybe, as we think about referendum and all that, maybe those are some of the questions that as Kenyans we need to ask. Do we need judges? Do we need lawyers in Judicial Service Commission? The question is out there because of those issues about conflict. It is not only the lawyers. We have the Attorney General, we have other judges, and those are basic issues that can have a perception that there is a problem. So do we need to include that as a part of our rethinking of our constitution?
All right. We have about 6 minutes before we go on break. We will be taking the audience questions in the second part. So I want us to quickly run through also important concern that has emerged. Campaign financing, that a lot of money during these campaigns that you are all involved in ahead of these elections, lavish parties or events being thrown out. Is there a need for regulation in the financing and how and what kind of monies are being utilized during this period? I'll start with you, sir.
It's very important. Not only in other democracies, there is finance laws during elections. Because we don't want money, elections to be basically about money. But I'm happy that even if you use your money, we are talking about lawyers. And when we are talking about lawyers, we are talking, because we have talked with the lawyers. I have no doubt that lawyers will go there. And you know, it's not Mororongo where those days you could see the person you give money. So if you give money, it's your own problem. But for me, this circulate ballot and the learned people, I have no doubt that whoever wants to use money, or state money, or whatever money you get, I don't care. Because I know the people are going, this is their stakeholders.
You don't care if the money is stolen?
Sorry.
What did you said you don't care if the money is stolen?
No, I'm saying I don't care whether you use your money or state money or anything. Me, I care that I'm talking to lawyers and they are listening because they are stakeholders and it's their position.
Macharia, has there been efforts in the LSK to govern this area, or is it that there's not seen to be a problem?
Actually, Sophia, this is an area that, in my view, having gone through this election, that needs to be given due attention quickly, because it will be very difficult for many good candidates to have any interest in participating in these elections if you have to be taken through a whole process that is similar to campaigning for a political position. It makes no sense at all. This is a professional position where you intended to serve. There shouldn't be any personal gain. There has not been adequate regulations, if I don't know of any, other than just simple mention here and there. we shouldn't be campaigning this way. It should be a question of debates like these ones. You have access to the members of the profession. You don't have to do anything out of the ordinary in terms of convincing your members of professional organization so that you can win, fair and square without having to use any money at all. Right. So for me, it's an area that I would support fully, that we need to regulate it very quickly. And that's a big failure on the part of Law Society, not having dealt with it.
All right, we will continue and get to hear your thoughts, the other two candidates, because right now we must take a break here on KTN News. You're watching this special edition of Checkpoint, the LSK debate for the position of the male representative to the JSE. We're taking a news break. My colleague Akisa Wandera is on standby in studio to bring the news. So this debate will continue after about 20 minutes. Please stay with us. When we come back, we'll also get to hear from the audience the questions they have and cover the other areas around the independence of the judiciary and the question of accountability. Please stay with us.